All right, this is an interesting question. At the same time, keep in mind, we're talking about private school transferring to private school. I don't know what state you're in, and that's going to be a big factor with regards to what your particular state regulations dictate pertaining to any kind of fund sharing with private schools and any kind of responsibilities that public schools may have with private schools within their boundaries. Now, does the federal law allow that, with regards to some collaboration or funding collaboration with private schools? Yeah, it does, but it means that it's an allowance, which means that it's also flexible and optional in most states, unless your state's very specific on what it allows with regards to public dollars being used in private schools, or having a child, let's say, that's homeschooled, even be entitled to any kind of IEP situation. Okay? So private schools, church schools, homeschool, those things sort of exist outside of the mandates of IDEA. Now, 504, ADA, different situation a little bit, okay? But, that's where the big question in my eyes is, jumping out at me is, what state are you in? Because I don't know if you're in one that does have some allowances or collaboration funding-wise, or entitlement to funding with the private schools, to where it's got to be sort of in conjunction or collaboratively with the public entity that the private school exists within. All right, because that's usually how the funding is distributed, is to the public agency where the boundary is, and the private schools within that boundary, and there's some oversight or some connection there. That is going to be the big red flag for me, okay, as I'm answering this. But you want them to test. Now, what I find interesting in this is that they sort of say, well, we want to see how the next 6 weeks goes. And what that typically means when a school system says that is that they're using it as some kind of screwed up response intervention time frame, to where sorry, I'm making adjustments to my gimbal. But that's where, that 6 weeks is typically what a school system will use to move your child through the problem-solving team response intervention, RTI process. But they shouldn't be doing that, because if you made the request, then if your child doesn't have an IEP, then that means that the school system, within the boundaries where you live, has a child find responsibility to identify and evaluate your child, okay, that is suspected of having a qualifying disability and be in need of specialized instruction. All right, so that's going to be sort of the big kicker, is that you made the request for your child to be evaluated. Now, both 504 and IDEA have a child find component, to where, it is up to the school system on whether or not or it's up to the school system to evaluate, to comply with their child find mandate under both 504 and IDEA, regardless of where your child is attending. Okay, so if you're looking for your child to be evaluated for, let's say, for an IEP, that has nothing to do with your private school whatsoever. Doesn't matter if your child's homeschooled, if your child's homeless, if you're a migrant family that's just there working, going somewhere else. The law covers all of that, which means that the school boundary for which you live has a responsibility to identify your child. Now, once you have that referral meeting, which you have a right to do, which means that you have a right to complain. If they continue to refuse to evaluate your child, then there's obviously there's a child find violation, and you can file a due process complaint. You would retain rights under that limited area to sit there and say, look, we asked for an evaluation, they refuse to evaluate my child, that's a child finding violation, okay? Now, what's the corrective action? It just depends on whether your child's eligible or not. Correcting that violation would be to have, the court or you through your resolution meeting or through negotiation to agree to, have a referral meeting. And at that referral meeting, get your consent to move forward to evaluate, regardless of where your child's attending. Your child doesn't need to be enrolled in public school to be evaluated. They just don't. They just need to tell you where to bring your child, and then they need to have somebody for some of the observation pieces go where your child is in order to complete all of that. It's not that difficult to do. This isn't brain surgery, so it's just evaluating your child. That's it. So with that being said, what ends up happening in this process, and I'm talking about IDEA, special education, I'm not talking about 504 right now. Let's say they do have a referral meeting, they do get your consent to evaluate, and they evaluate your child, and then you go to an eligibility meeting. Let's say they find your child eligible. What then? Unless you live in a state to where there are very specific allowances to where there's funding sharing or collaboration with private schools, your child, the school system's responsibility at that point is to say, yes, your child's eligible, and here is what we propose we could do. But it would be contingent upon you unenrolling your child in his private school and enrolling your child in the public school. And that's how you would have the IEP. Unless your state allows, or that particular school system will agree to serve your son in the private school location. Now, other than that, as far as 504 is concerned, does your private school accept any kind of state funding, any kind of federal funding? Because if that's the case, then they would be, 504 ADA would be applicable at that point. ADA would be applicable whether they accept a federal fund or not. But 504, with regards to the protections and your child's right to a FAPE under 504, would sort of be contingent upon whether there's state dollars or federal dollars being exchanged there with your private school. They're sort of right. The school system really doesn't have any responsibility under 504 if your child's in a private school. The private school would be responsible for that, but only under these parameters that I just explained a second ago. Now, under special education, the public school's only going to be responsible to the point of evaluation and determining whether your child's eligible or not. And at that point, depending on your state law, it could go this way or this way. But unless you want your child enrolled in a public school, let's say you live in a state that doesn't do this, private school, compensation or sharing of state or federal dollars. And then if your school won't voluntarily agree to do that, but they'll say, well, you unenroll him over here and you enroll him over here and we'll give him an IEP. That's what you'd be looking for, or that's what you'd be looking at in a lot of situations across the country. So you sort of have to weigh, what you're doing. But like I said, everything's contingent upon where you live. Because even though we have a base federal law, a lot of the states are different in how they spend their funds and share that with private schools, okay? And, you just got to sort of check where you live and how those rules apply, okay?